and welcome to Dawn News English. I'm Nadia Naqi with you, and we have with us today Advocate of the Supreme Court, Ahmad Hassan Shah Saab. Thank you so much for joining us. If you recall, Ahmad Hassan Shah Saab is more popular since he was the counsel for Akbar S. Babur in the foreign funding case. However, today we're not discussing that. We're discussing the National Assembly that passed the bill today. And the bill is known as Supreme Court's Practice and Procedure Bill 2023, which aims to deprive the Office of the Chief Justice of Pakistan powers to take Suo Motu notice in an individual capacity. A lot happened today in the Assembly. There were very fiery speeches on the floor of the House. However, for this bill to become an act, of course, there is a consent that is required from the President of Pakistan. We still have to see how, that is how he scores on that one. However, the reason why this is being done was most discussed since yesterday and has been under discussion. There were a lot of things that were said today on the floor of the House that we may discuss today with Advocate Supreme Court Ahmad Hassan Shah. Thank you so much for joining us. Initially, I would like you to give your comments regarding the bill. Do you think this is the right step in the right direction at the right time, as Khurram Dastagir today termed it on the floor of the House?
First of all, thanks a lot, Nadia, for calling in, and it's always a pleasure to come and talk to you and through you to a lot of people. I only wish that the times were more congenial for a talk, but times keep changing, and we ought to do what we ought to do. Now, coming to your question, and I'll take it head on, any kind of discipline in any decision-making process is welcome in any worthy societal setup. So long as the people or the people's representatives or the people's or the people entrusted with discharge of duties such as this, and they set out to put in a mechanism for a transparent, for a fairer, for a more open, inclusive kind of a decision-making process, that in general is a welcome step. Now, regrettably or for whatever reason.
So when you say it's a welcome, and you rightly put it why you say this is a welcome moment, but do you think it would have been better that instead of the Parliament, this should have come from within the Supreme Court?
I was going to finish my opening with this, that it is, though regrettable, that the effort is being tainted with some kind of an agenda theory. We've recently become a people who put or attribute intentions, sometimes good or bad, to a lot of actions that our opponents or people who we do not agree with do. Now, I will try to speak to you as plainly as I can, but these are intrinsic legal constitutional issues here. Now, my sense is that this is not going to go uncontested. It is not a simple, straightforward issue where the Parliament, being the body responsible under the Constitution for lawmaking, can just come up at this point in time and say, well, I am the legislative wing of the state and I am going to pass this law, and the Constitution allows me to do it. I sense that there is going to be a challenge to this law.
Okay.
That challenge, to my mind, is not going to be just for the heck of it. There is plenty, I would say, in the plain language of the Constitution, which could say that, or could give room, or does give room to the argument that this should in fact have come in from the Supreme Court itself. Now, I would like to make a very simple point. The Constitution of Pakistan entrusts the Parliament with the lawmaking process.
Absolutely.
Now, people forget that the word Parliament, or Majlis-e-Shura, as the Constitution calls it, it comprises of three different sets: the President, the National Assembly, and the Senate. This is, in common parlance, when I talk about Parliament, people think that we talk about the National Assembly.
National Assembly, yeah.
And if you're talking about on a provincial we're talking about the provincial. But Article 50 kind of sets the scope as to what is Parliament. It kind of defines it. These three things make the Parliament. Now, then the next step I would suggest is that the Constitution allocates business. Who can do what?
Okay.
It creates certain institutions and it allocates responsibility and the conduct of business of the state. When it talks about the lawmaking power, there is a concept of a list, a federal legislative list. What laws who can make? This is what the Constitution says. And this list kind of emanates from Article 70, and the allocation of business is more specifically addressed in Article 142. 142A is the more relevant article. And let me see if I can quickly refresh my memory to see. That basically gives an exclusive power to the Parliament to make laws with respect to the matters in the federal legislative list.
Okay.
So I'm just trying to go simply step by step. Then the relevancy comes of, does 184.3 or the exercise of power by the Supreme Court under Article 184.3, we call the Suo Motu powers, the enforcement of fundamental rights of public importance and so forth. So what is the nexus with that? Now, to understand that, we need to read, at least to my mind, at least others as well, but at least to my mind, two other provisions of the Constitution. One is Article 191, and the other is Entry 55 of the Federal Legislative List.
Okay.
So when the Constitution says in 142 that the Parliament shall have exclusive power to make laws, it is subject to the Constitution. Now, what does Entry 55 say? Entry 55 interestingly talks about the jurisdiction and powers of courts. And I haven't, since I've not been privy to a lot of discussions on this that have gone over on the media, so I don't know if anybody has adverted to it as of now or may well do it. Now, this Entry 55, let me take that out also. When it talks about the jurisdiction of the courts, it has a very interesting concept to it.
Okay.
And it talks about whether there can be an enlargement of jurisdiction of the court. That is the Supreme Court we're talking about. Now, this 55 entry basically says that the jurisdiction and powers of all courts, except the Supreme Court, all courts except the Supreme Court, with respect to any matters in the list, and to such extent as expressly authorized by or under the Constitution, including enlargement of the jurisdiction of the Supreme Court.
Okay, so you're saying that this is going to be contested. This is not something that is going to be just taken and accepted.
No easy right. Now, when you read this with Article 191, Article 191 is the provision which actually reserves the right of sort of making rules for the Supreme Court. And when it talks about how the business at the Supreme Court is to go about, Article 191 in very plain, simple language reads that, again, subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the court. Now,
and exactly, this is what the law minister today said at the floor of the House, that the laws is what we're going to make, and the rules come under the laws. So there's going to be a constitution, then there's going to be legislation, then there's going to be the laws, of course, and the rules underneath that.
So I'm not contesting whatever he said, but I'm just saying that I don't see this going through or sailing through without a challenge. And the challenge that is likely to come is likely to be founded on reading of these provisions. So now we will enter a new phase where these provisions will be interpreted. And one question that I guess one must wonder is that if it could have been done by the Parliament without regard to reading 142 with the entry 55, then why not before? Why expressly state that the Supreme Court actually does it, and the Supreme Court has done it? Now, in effect, in other words, what has happened is that these rules are being amended by way of a law. This law has come in, yes, this law does not cover every possibility or all rules and practices at the court. It only talks about certain aspects related to the conduct of business by that court. So this is going to generate, in my assessment, a new set or a host of new conflicts, and the people who are presently on the legal academia side, on the legal practitioner side, on the political party side, they will all now start sort of gathering up and developing their arguments for and against this.
Okay. Now, there are 2-3 things that I'd like to ask you. As a legal expert, do you think, yes, there was a need, that this Suo Motu business, the way it has been taking place in Pakistan and today in the parliament, it started off from Iftikhar Chaudhry's era. This should have been sorted out. There should have been a full court, which has not taken place since 2019 to sort all of these issues.
Well, like I said in the opening comment, a case for revisiting the manner in which this power is to be exercised is well made out. And yes, this particular provision or this exercise of power initially gained a lot of popularity during the tenure of the former Chief Justice Iftikhar Chaudhry. But then it also transformed in some kind of a notoriety as well. It became a notorious thing. A lot of criticism started to take place. But what we've seen is that there has been increasing intervention into other affairs of the state by resort to this jurisdiction. So yes, I agree with you that the case is well made out, and like the courts, including the Supreme Court, and even in the recent decision, they talked about structured discretion by other agencies or other organizations or institutions of the state. So why not the Supreme Court? And I believe that these matters, however, require attention of the full court. Well, we understand that the way the business is done at the court, it is split into benches, and the benches are to be formed by the Chief Justice and all that. But you see, times need to be kept in perspective. Kind of misgivings that are now beginning to arise and are engulfing all institutions or organs of the state. Now, I guess it is the opportunity, it is the chance for the Supreme Court to take one step forward and say, well, hey, this is the Supreme Court of Pakistan. All of us, are serious about this issue. We want to resolve this issue. So let's start with how we do things. So this is the time to rebuild confidence. Unfortunately, a lot of people, even when I was a younger lawyer, when I started off about 28, 30 years ago, we heard our seniors talk about, the controversy. They would say that the judiciary has a checkered history. I remember this phrase from our teachers like 30 years ago. So that is what the commentators or historians have documented. So now is the time. Are we going to continue with a checkered history of sorts? Or is this the time that when we say, well, okay, let's have a look internally, let's all put our heads together, let this talk of a divided Supreme Court be dismissed once for all. The Supreme Court is the Supreme Court.
And but is this just a talk? Ahmad, do you really believe it's just a talk? There is no division?
No, you and I are not witnesses to the division. You and I make those assessments based on the decisions that come out of the court. Now, well, if there is that impression, if there is that perception, whether it is minor, major, growing, well, people do talk about it, and at times people do not talk about it in very gracious terms. So, as an institution, now is the time for the judiciary to regroup and speak on these points, not just this point, speak on these points as one voice. Well, I don't see. I've been insisting with whatever groups that I have engaged that yes, there has to be a full court. If all of them can get together over a cup of coffee or tea to bid farewell to a colleague, they can come together to decide important questions of constitutional law.
And this actually has drawn a lot of criticism that why is the Supreme Court or why is the office shying away from a full court? Why not a full court? Well, let's see, as you have pointed out in the initial conversation that we've had, that what could be the points brought in to challenge what the National Assembly today has done. So in the end, I would like to ask you, do you think that there's also another question that was being raised, that this should have been done through a constitutional amendment rather than in the form of a bill, to which the law minister, of course, had said that no, there was no need for any sort of constitutional amendment. As a legal expert, what would you say on this?
I kind of appreciate and I kind of agree with that assessment that this particular exercise may not require a constitutional amendment.
Okay.
But there are 2 or 3 aspects to this amendment which need to be segregated. As far as the right of appeal is concerned, that is a totally different matter. That could and can only come by way of a legislation.
Okay.
Now, the issue of hearing Suo Motu cases is distinct from that issue. While one can argue whether or not that right of appeal lies or not, there is precedent, there are laws in the country which provide for an appeal of sorts within the Supreme Court and other courts. But here the issue is distinct. The constitution of the committee for purposes of exercise of the Suo Motu powers under 184(3),
right,
to be viewed on a different, that is practice and procedure of the court. Now, it is to that extent that I submitted that list of relevant articles to you, that I do not refer to when I'm talking about the other changes that or other positions that the law now presents before us. So I should have clarified earlier, but my focus was on the practice procedure when I was talking about that.
All right.
And obviously then there is the other issue of review, to have the right to choose a counsel. So these are the different themes that the law brings, and much of what I said relates only to the 184(3) practice and procedure. I don't want to be receiving calls from my colleagues, senior and junior, telling me that you've misquoted this article because that relates to ABCD. So I was talking in general in layman terms, but now that we came to this, I thought I'd clarify that point.
All right. Thank you so much. Let's see what is going to happen in the coming days. But as of now, the Parliament looked very confident in the entire, I'd say, expression or the body language of the Parliament was that, the Parliament is supreme. It is the parliamentarians that shall decide what is right. At one point, it was asked that why was this not done earlier and why is it being done in haste right now? To which the law minister had said that because there has been a division within the institution itself, or rather What he meant was that there were voices now coming from within the judiciary. So we thought that this is the right time to pass this, a bill in the National Assembly. And so this is how, this all came into being. Let's see what Imran Khan is going to do, because since yesterday we've seen Imran Khan, of course, the former prime minister and one of the largest opposition parties, sitting outside the parliament, has been saying that this indeed is an attack on the independence of the judiciary.
Let me just quickly, if I may, I know we're running out of time.
Yes, sure.
You see, in more developed legal systems, there are people who track decisions of various judges. For instance, you have had occasion to witness the sessions with the Senate in the US nominations to the Supreme Court. People have developed a mechanism that they track that a particular judge has a particular view in cases throughout his career.
Okay.
In Pakistan, we do not have this organized approach on how a particular judge may respond to a particular issue. And we do not necessarily have a data bank to anticipate that Mr. ABCD Justice did so and so in cases ABCD and is likely to do so in F. But in other countries, you have this mechanism. But with courtesy to the media and repeated interventions and involvement of a lot of people in the decisions, what has happened recently is that people do anticipate now that XYZ Mr. Justice is going to react in this manner in that particular case. So this amendment, I would suggest, is not targeted, in my mind or to my assessment, to one particular Chief Justice. This amendment is to see possibly in the future that maybe there will be someone who is not as gullible as many people would like to, for want of a better word. So this is in what you can perceive, this is one part of the organ of the state to put a check or balance on another organ of the state to see, well, fine, go do what you wish to do and want to do and ought to do, but then there has to be some kind of contours that need to be determined. And unexpected.
We've really run out of time and we have to close the show. Let's see how this organ is now going to behave, I'd say, with one organ of the state saying something regarding this organ. But thank you so much for being with us. Let's see if, this is going to be, because as you said, even earlier in the beginning of the show, it is always right that, there has to be a consensus or some sort of discussion being done. But how the Supreme Court is actually going to take this bill is only, we could say that we could see this in the days coming. That's all for now. Thank you so much for participating with us.
Always a pleasure. Take care. Bye-bye.
Bye.